This is Speak Up. I am Sandra Shulte. Welcome back to our show. Today I have a gentleman called Simeon Baum who's going to speak about mediation. Simeon Baum is president of Resolve Mediation Services. He has successfully mediated over 1,000 disputes, including the highly publicized one-time big mediation between the architect Libiskin and Silverstein Properties. Remember Larry Silverstein? Over fees related to the rebuilding of the World Trade Center. He is also mediated Donald Trump's $1 billion suit over the West Side Hudson River development. He also was involved in a mediation concerning Archie Comics. Now, you young people won't remember Archie Comics and Archie and Veronica, but us older people, that rings a bell. Simeon Baum was selected for New York Magazine's 2005 through 2014 Best Lawyers edition and Lawyer of the Year for Alternative Resolution Disputes. So if he talks about ADR, remember ADR means Alternative Dispute Resolution. Anyway, that was for the years 2011 and 2014. For over 30 years, Mr. Baum has mediated claims, so it has quite a track record, concerning financial services, fraud, security industry disputes, insurance coverage, property damage, personal injury, bank fraud, and the list of subject matter just goes on because he's been doing this for 30 years. Mr. Baum's peers have such high regard for him that they appointed him to the Alternative Dispute Resolution Advisory Group of the Supreme Court of New York County, the Mediation Ethics Advisory Committee for the New York State Court System. He is a founding chairman of the New York State Bar Association's Dispute Resolution Section, and his credits go on and on and on. He has taught alternative dispute mediation at NYU and Benjamin Cardozo School of Law. He has developed, and for 20 years, he has conducted a 3-day training program to train mediators for the Commercial Division of the Supreme Court of New York, Queens, and Westchester County. That's big stuff. To know more about Simeon Baum, simply type his name into your computer. I am truly impressed. I'm so glad you were able to come and be present for this show.
And I know as a litigator, I always kind of wanted to get the cases resolved.
That's your personality, the different personalities.
That is true. I know it was my personality, but I think there are more litigators out there who really want to do right by their clients and want to, because if you go to trial and you lose, no client is happy. If you go to trial and you don't get exactly what they want, they're still not happy. And if you go to trial and you get what they want, but it's cost them a fortune, they're still not happy. And there's all sorts of uncertainty. No matter how great an advocate you might be, great a trial lawyer you might be, you don't know. You can't guarantee the outcome.
That's correct.
So litigators, too, like to be able to produce a deliverable.
Now, I'm going to ask you a question. What situations or preconditions are good or not good matters to mediate?
Okay. My view is that as long as it's a dispute, anything is good for mediation. That's, there are a few rare exceptions. If you're trying to make, say, a Supreme Court precedent to make social change, and you want to get a case on the books for that purpose, you might want to litigate and get your decision. But I've heard people say, oh, it's too early, they need more discovery. No, the mediator can help parties come into the process and do truncated disclosure. In the litigation process, you've got interrogatories and document demands and depositions, and it can cost a fortune and take a really long time. And as somebody who used to draft answers to interrogatories or interrogatories and all the other discovery devices, it's tedious and boring. And nobody likes being bored. You could put in a letter, or an email, the essentials of what you're looking for, and shoot it to the other side, and they can get the essential stuff. And it can be much quicker, and faster, and to the point. So that's why when I asked that question in my opening joint call for the pre-mediation call, I'll say, before we get together, what do you need? That's what I'm looking for. Maybe nothing. Maybe they say they have everything. But so is a case premature? I don't think so. I think the earlier you get a case into mediation, the better. The less hard and fast people's positions become, the less baked in the anger is.
Yes.
And frankly, from an economic standpoint, the sooner you mediate, my observation is, I've been a mediator. I've done a whole range, of business mediations, but I've also done probably a few hundred employment mediations. I've done them for the Postal Service on their redress program. I've done them for the EEOC. It's a little bit later. I've done them in court and independently when they're pending in court. So that's like the early claim, and full-blown litigation. And when cases settle, the earlier they settle, the fewer the dollars that get exchanged, typically. Sometimes you get super early settlements of employment matters where there might be a little, extra kicker, that if somebody's a person of high public, a public figure, or is married and it's a sexual harassment claim or something like that, and there might be, other issues, and the lever there for the claimant's attorney, frankly, is you've got a choice. I'm about to sue you, and this is going to get public. It could have a negative impact on your family and on your job. So settle now before it all happens. So there, actually, some of the dollars can actually spike because for the purpose of, but that raises a whole set of issues on the question of, is that appropriate to use that kind of leverage to bring about those kinds of resolutions? Conversely, it's still about freedom. And one thing I'd like to say is that one of the beauties of mediation is it's all about the party's freedom.
Freedom?
Freedom. If you're differentiating now litigation, arbitration, the others, if you're in litigation and you go into court, now you got to follow the rules, and you're subject to the court's deadlines. And
I don't know. My impression is that every court deadline gets extended.
Well, that is very true. You're so right. But try to be the guy who's been served with an order show cause on a Friday before a nice summer weekend, and it's returnable on Monday. The lawyers, at least, are going to be working over the weekend trying to get something done. And you're absolutely right. But there also are deadlines and rules. Rules of what can and cannot be submitted in a trial. Rules of admission, rules of evidence, and in the end, somebody else makes the decision. A judge, if it's a judge-only matter, or judge and jury, right? So you, the party, you lose control. It's out of your hands. And not only that, it's in your lawyer's hands, who's costing a lot. So, so that one of the major differences then is that the judge and also the arbitrator makes a decision, the jury makes a decision that's binding on the party, but the party is bound by that. When a case is over, by the way, there's a quality of force in litigation. We talk about the pleadings. There's a complaint, and then people produce an answer, and the answer contains defenses. You know, it's a little warlike. We got our defenses and our counterclaims. And when they go and get discovery, they use subpoenas. You know, a subpoena comes from the word penalty. Pena is penalty or pain. It was just based in pain. And when a case is over, there's a judgment, which shows you the use of judgment. A judgment, and it's enforced. We enforce, that's our language. We enforce the judgment. So you see the word forces in there. So all this is happening to
How is it,
people.
How is it enforced?
With the sheriff or the marshal.
Okay.
If the sheriff, if you are served with a subpoena and you don't come to give your testimony or deliver, you know, whatever it is that the subpoena is seeking, they can get it, the marshal to come along and throw you in the clink. So underlying our litigation system, although it's a lot better than, you know, warfare, and it's a wonderful and important system because it establishes expectations for norms, behaviors, and has with it the notion of justice. However imperfect, it still has that notion of justice.
So in other words, if the guy doesn't pay off the judgment for whatever it is, the sheriff can come in
and take his stuff.
Yes.
Physically, by force. Or if he's asked to come to enforcement proceedings, post judgment proceedings where he's going to disclose where my assets are and he doesn't show up, they can actually hold him in contempt and put him in jail. So all of this is to say, Sandy, that the litigation system is a system that's somewhat coercive. Mediation is different because the neutral has no power. And to me, that is one of the true beauties of the mediator.
Are there different stages in mediation, such as different stages in the grieving process, such as different stages in growing up, like infancy, childhood, adolescence, adulthood, old age?
That's a great question. So, yeah, I mean, I started talking about preparation. You know, there's the preparation where the mediator prepares and where the parties and lawyers prepare. Then they get together. There's that, to me, opening joint session is fairly typical. And they get a chance. The mediator makes an opening. The mediator's opening during the opening joint session is key. It's like the blitzkrieg, you know, that first touch. And you want to send the right message. You tell people this is a confidential process. That's a very important aspect of mediation. In court, it's not confidential unless you got a confidentiality order of some kind. And it's hard to get things under seal today for public right to know reasons. But in mediation, it's confidential. So you let people know that, and you let them know it's so that they can talk comfortably with each other, and you know, let their hair down and share their emotions and share with their interests. Because only if I learn what you want, only if I know what you want, can I get you what you want. If you keep it to yourself, who knows if you're going to get what you want. So, that's a stage, that first opening joint session. Then, typically, I, as the mediator, if I've introduced the process, talked about my role, which I've been doing so far here, the next thing the mediator does is turns it over to the parties and says, okay, maybe you'd like to talk a little bit about what it is that's brought you here and what you'd like to see come out of the day. It's kind of ball over the plate invitation to say something. And that's often a chance, and that's, if you've got lawyers in the room, there is a decision, who's going to talk, the lawyer or the client? I always tell people, I encourage parties to talk, because it's a party. This is, again, an area, unlike litigation, where the lawyers control it. The lawyers in litigation will do direct examination, cross-examination. The witness is not allowed to just say, oh, by the way, I just want to talk about something else. You know, the witnesses in litigation, at trial, they just have to respond to the question and not go beyond that. But in a mediation process, it's wide open. It's free flowing communication. And it's the parties have a very valuable role. They have the right to speak. They're the ones who are going to live with the outcome. They're the ones who will make the decisions. So I always invite them to speak. Having said that, I don't stand in the way of strategic choices made by lawyers and clients on who is going to speak. If the client and lawyer feel more comfortable letting the lawyer kick it off, so that's how it goes. But that's empowerment of them through their process choice. Because mediation is very much about, because of the freedom component, it's very much about empowerment, empowering the parties, empowering everybody who's participating in this process to make choices about process, as well as what to talk about, whether to talk, whether to walk, whether to, what kind of deal to make, what proposals to make, all of that. That's the freedom and empowerment component that the mediator helps people take advantage of, utilize. So that, you asked me about stages, just to continue the stages, I'm sorry. But after that opening, there could be dialogue at that joint session, and there's no rule. The joint session could go until the case is done, the matter is resolved. Or at some point, people might feel that maybe it'd be helpful to take a break. And the mediator might also feel, hey, I think they've now one of the benefits in joint session in that first stage of the in-person session is that it's the first time that the parties on the other side of the table, if in a business dispute, let's say a business litigated dispute, get the chance to hear what the people on the opposite side of the table have to say. So they get to hear that, and they can actually have a discussion about it. And the art of mediation is to enable them to have a meaningful discussion, a thoughtful, let's wonder together kind of toned discussion, where they are reflecting on what's being said, as opposed to simply trying to bash each other over the head with it.
Or someone that has a whole lifestyle, a whole history of getting her way that way.
Right, and so and so in mediation, we have to find ways to enable people to speak, but to understand that they are, as the mediator regards the freedom of the others, to help others regard the freedom of the opposite party. So, so after that initial joint session, they might break and say, let's talk privately, and those are the caucuses. And we can go for caucuses from that point on quite often in a commercial matter. You can go all day, back and forth. The mediator, now in caucus the rule is, if I talk to you in caucus, whatever you say to me, I can't say to them unless you tell me it's okay. If you tell me it's okay, then I can say it to them. And frankly, what really happens is you go back and forth, and after the first caucus, I won't say to you, I might just say to you, Sandy, is there anything that I may not say, rather than what's okay to say, because you'll often in those first caucuses be telling me all these things that you'd love me to say to the other party. And as Jackie Drucker, a mediator, used to say, what the mediator does is rinse and repeat. I take the nasty stuff out of the statement and I deliver the essential message to the other party. The mediator as editor in those processes of caucus is a significant role, and it's a challenging role, because on the one hand, you want to help you're trying to help the parties communicate with each other and be understood. You can't impede one party from delivering a proposal to the other party. But say the proposal is go, jump off the Brooklyn Bridge. Okay, so you want to find a way to share initially first with the proposer, do you really think you want to say that to them? If you say that to them, how do you think they're going to respond to you? And then you try to work to get a proposal that's a little bit more palatable. If you're still delivering a pile of malodorous material to the other party for consumption, you might then manage the expectations of that party as you're about to deliver it. Okay?
Wow.
All right? And so then as the mediator delivering that message, you find a way to deliver it so you say, listen, I know this is tough. I know this is our first, say it's the first proposal that's heard. You know, the plaintiff is demanding $10 million in a case that the other party thinks is worth nothing. And you say, I know you guys think that this is, you know, a challenging case for them. We are getting started. Here's a proposal. I know it. I can tell you right now, you're not going to like it. Now, some might say, oh, why should you put negative projections on them? But at a certain point, reality comes in, and yeah, an understanding of people and an understanding of who's hearing and who's communicating in the context. And so the mediator kind of works through with the parties the delivery of messages back and forth so that they can stay at the table. I think one of the most significant things services a mediator does is keep people at the table. As long as they keep going, eventually that matter will get resolved.
Are there different styles of mediation?
There are, actually. So you heard me say, make that comment about understanding and deal making. Himmelstein and Friedman are two mediation trainers and thought leaders, Jack Himmelstein and I think Gary Friedman. And
Gary Friedman.
You know him?
Yes, I do. Oh, yes, he specializes in wills and trusts.
I don't know if that's the same one.
Maybe not.
But
What's the name of this company? I can't think of it.
but
ahead.
I think, and I hope his name's Gary. I know it's Friedman.
Okay.
For years, the model they've used for training mediators on how to be mediators
Yes.
is what they call this understanding-based model. And their notion is, say in the case of Jones v. Smith, how do you help parties get beneath the V? How do you get them to the common ground on which they live? And their view is that by bringing the parties together, transparently enabling them to see that they're in this matter together and building understanding, that the matter will get resolved. What's one unique thing about their view is they don't believe in ever leaving joint session. There's questions, if the mediator has confidential communications in caucus, which I'll do. And some people say, well, how do you deal with confidentiality? The party A tells you, here's a really strong part of my case, but you can't tell it to party B. Then what am I supposed to go? Go to party B and say, party A says they've got a really strong thing in their case, but I can't tell you what it is. You just have to take my word for it. I mean, and who becomes the power player? I told you about the filtering process. The view is, should the mediator be a filter? Or should the mediator be like accent, monosodium glutamate, helping enhance the messages of one another so people can understand each other more clearly. And so should the mediator be and also caucus to caucus, separate rooms, reinforces the separation between parties. So that if you're in this room all day and Joe's in the other room all day, by the end of the day you think, not only do you think Joe is a horrible idiot, you think he's the worst idiot in the world. Because you've spent the whole day hearing things from him that piss you off and making communications to him that he doesn't accept. And the parties will build the circle the wagons and they have these little war chants in their rooms, and especially if you've got these large groups with the lawyers and the corporate representatives and everybody. By the end of the day, the possibility. See, mediation. There's a book by Bush and Folger, and they're a different school, transformative, which I'll talk about in a moment. But they call that the promise of mediation. And the promise of mediation for Himmelstein and Friedman, the understanding-based model, is understanding. It's not just about money. It's not just about settling a case. It's not just about making a deal. It's not about solving a problem. These are all other models. It is, people can come to a deeper understanding of one another and realize one another's humanity. and on a deep level, and there's some real satisfaction in being understood. So that's one model. The transformatives, by the way, and I don't know if Sandy, if this is going too far afield. So the transformatives, Bush and Folger in their book, I think in 1993 or sometime like that, wrote, again, responding to other models of mediation. And maybe before getting into that, I should talk about the more obvious models of mediation. The most obvious model of mediation, which I mentioned very briefly at the beginning, was the judge mediator. I have nothing against judges. Any judges out there, I love you. You know, judges are great and bring wisdom and law to society, and that's very good. Some judges are used to having a lot of power. And when they get in that mediator seat, they think their job is to tell people your case is bad, your case is good, or that's a valuation, or to tell people you should settle this case for $350,000, not a penny more, not a penny less, telling them what to do. Now that's a very simplistic view of how some judges might approach it, but there is a component of evaluation and directiveness that is kind of associated with judicial mediators of 20 years ago. But there are a number of judges who, by personality and orientation and skill, are fantastic mediators. They understand that the mediator's role is different, that the mediator is the background player, that it's about the parties and not the judge, that it's about what the parties think and not what the judge thinks. It's about the parties' choices and not about the judge telling what to do.